Floyd Zadkiewicz, International Commercial Lawyers.
I'll keep it moving. My name is Tim McGovern. I'm a partner in Chicago. And I'm not going to disturb the artwork here. So if you want to view it up close at the conclusion of our discussion, then you're welcome to. So I'm here to talk about personal injury. I've been handling personal injury claims throughout the last 18 years of my practice. But in preparing for today, there have been a number of decisions that have come down just in the last 3 weeks. And the common theme in each of these, and the thing that I plucked out from each of these, is the importance of understanding maritime jurisdiction when you're dealing with a personal injury case. The first case I'm going to talk about is something most of you are probably pretty familiar with, just a general industry. It's the Branson duck boats. And for those that aren't familiar, last July of 2018, a duck boat operating on Table Rock Lake in Branson, Missouri, was swamped by a storm. 17 people died. There were multiple personal injuries that resulted from it. There was a lot of press coverage saying it could have been prevented, that the duck boat company never should have gone out. The results industry-wide have been that many of the duck boat operators have been unable to place insurance, and many have gone out of business. From the legal perspective, there were claims filed in courts in the Western District of Missouri and in local courts seeking damages in excess of $100 million for the personal injury and wrongful death cases. There was one particular woman on board. She was there with her family. She lost her husband, her 3 kids, her aunts, her cousins. A total of 9 family members of hers died. She was the only one that survived. Her case alone, they've placed at $100 million when they sought damages in the Western District of Missouri. So the duck boats ultimately were owned by Ripley. If you're familiar with Ripley's, believe it or not, the wax museums, and they owned all sorts of entertainment related companies, and they had just purchased the vessels in the months preceding, or maybe it was about the 12 months preceding this incident, from duckwater excursions. And the Ride the Ducks Duckwater filed a limitation action in federal court. The Limitation of Liability Act can reduce the value of a claim to the value of the vessel and any pending freight. And in this case, they were saying that, well, the duck boat was swamped, sunk to the bottom. It has 0 value, and therefore the global value that we can pay out on all these cases is $0. You may imagine it did not work very well. And actually, the decision that just came out on Wednesday, on November 27th, the court said there's no maritime jurisdiction over this case because Table Rock Lake is not a navigable water. And secondly, Ride the Ducks, who is the company that was seeking limitation of liability, as a former owner, could not assert the Limitation of Liability Act, and therefore the claim failed. What's also interesting, as a side note, though, is that anybody who remembers the Staten Island Ferry will recall that the operations manager and general managers of the company were criminally prosecuted for their role in allowing certain things to happen that may have caused or contributed to cause the incident. We already have a federal court that said this is not a maritime case related to the duck boats. Yet the general manager and operations manager of Ripley's Ride the Duck excursion are being prosecuted by the United States Coast Guard. So it's going to be interesting to see how that plays out. The lesson, though, is if this was not on Table Rock Lake, if this was on a navigable water, the Limitation of Liability Act can be a very powerful weapon if you can get it enforced. It's difficult to enforce, but the value of filing those cases as far as settlement and essentially confusing plaintiffs' lawyers has been used for years and years, and it's very effective. And by the way, all but one of the cases from the Ride the Ducks has been settled now. There's only one case remaining out of all of it. None of the settlements have been published yet, but they're said to be substantial. So I don't know if anybody here is involved on the insurance side. I won't ask any questions, but I think that those are going to all get wrapped up here pretty soon, at least from what I understand. Next case I wanted to talk about is a case from the Western District of Washington. Thomas A. Deem was a machinist, and he worked at the Puget Sound Naval Shipyard. He worked as a machinist, like I said, and he was on board vessels that were docked or dry docked there, and developed mesothelioma, which is asbestos-related cancer. And I'm sure we've all seen the late night commercials, mesothelioma. Well, I can tell you in Illinois, just in Madison County, which is the smallest little county down by St. Louis that most people have never heard of, they collect $1 billion in settlements every year for mesothelioma cases. This litigation is not going away for a long time. They will keep finding people. They spend approximately $40,000 to $50,000 per case in marketing cost, but they also recover a minimum of $1 million per case. So these cases are going to be around for a long time. And the reason I bring up the Thomas Dean case, because it's a strange jurisdictional issue which relates to maritime law. Normally, at least in my experience, it's usually the defendants that are saying maritime law should apply here because there's some good defenses. In this case, Mr. Deem got sick. He was diagnosed with mesothelioma. He didn't do anything for years. He passed away. And by the time his estate filed the lawsuit, the statute of limitations would have run for his personal injury case, but for his death. His family filed their case under state law, and under Washington state law, he was time barred because the time for filing the original case had expired, therefore the time for filing the wrongful death case expired. In this case, the plaintiffs then said, well, wait, this is a personal injury case under maritime law, which is subject to the doctrine of laches, which Ed talked about. And laches is generally, did you sleep on your rights? But they do look to state law to determine, just as a guidepost. And in this case, the judge punted on the issue of whether this was a maritime law case, the jurisdictional question of maritime law, just to get to the bottom of it, and held that the maritime standard for mesothelioma cases requires either direct evidence or frequency, regularity, and proximate exposure to the asbestos-containing materials of the defendant. We don't have that evidence. Therefore, under maritime law, I'm granting summary judgment, and completely skipped over the jurisdictional issue. But had the jurisdictional question come up, then the statute of limitations may have changed, not in favor of the defendants, but against them. Third case I wanted to touch on was Terra Tonya Levitt, and this is a cruise ship case, a New York plaintiff. She was on board a Mediterranean cruise, and she was injured. $750,000 in medical expenses to date. Significant injuries. She hired a lawyer, filed suit in the Southern District of Florida, where many of these cases are heard. And the lawyers pointed to the contract and said, well, had this been a U.S. case, a U.S. cruise, yeah, we would have to be in the Southern District of Florida. But it was a Mediterranean cruise, therefore Italian law must apply. Suit must be filed in Italy, and the Athens Convention applies. So the plaintiff said, well, you're depriving me of a cause of action. Italian law isn't going to pay me anything. I have $750,000 in medical expenses, and the Athens Convention will only pay me $65,000. Oh, and by the way, my daughter booked the ticket, so I didn't get a chance to read the terms and conditions. And the Southern District of Florida said, too bad. They appealed to the 11th Circuit, and this was also last Wednesday, 11/27, big day in maritime law. The 11th Circuit affirmed the dismissal and said you're subject, you have to go file in Italy, which is going to cap their damages at $65,000 under the Athens Convention. If you think back to the Costa Concordia, it was a similar issue where the plaintiffs' bar were trying to file suits all over the country, whether it's Florida. Actually, the first case was filed in Chicago. It didn't go anywhere. All of them seeking significant settlements, significant funds, but the Athens Convention was going to limit those as well. Not that anybody wants another Costa Concordia, but if it happens, we now have some 11th Circuit precedent that's even going to further help enforce the Italian jurisdiction clause for the Mediterranean cruises. Obviously, it can be extended to other areas. And the final case, this is an old case. It's from November 11th. Devon Barrios, this was down in Louisiana, and Mr. Barrios was just an employee of a marine construction company, and he was transferring a portable generator from a crew launch to the shoreside parking lot, and somehow between the crew launch and the dock, he fell and the generator hit him in the head, and he was significantly injured. He was very badly hurt. So he filed suit based on the Jones Act and general maritime law against both his employer, which was a company called Centaur, and then also the contracting party on the maritime side of it, which involved the launch, who owned the launch boat. And the launch boat said, wait, our contract with the employer has an indemnity provision. And I think anybody here who's been involved in some logistics or maritime personal injury work, the indemnity provisions are very important because everybody's going like this by the time you get to court, tenders of defense, all those other issues. And in this case, the vessel owner said, we have an indemnity provision. The employer has to provide us with full and complete indemnity. This is a maritime issue. He's transferring from a launch boat to a dock. Maritime law will enforce the indemnity. The trial court said, no, this is not a maritime contract. This is a contract for the building of a dock, a shore-based facility. Maritime law is not going to apply, and indemnity provisions under Louisiana are unenforceable. The case went to trial, and actually the employer was dismissed because there was no finding of maritime law. The Jones Act law case failed, and the employer was dismissed. The case went to trial while appeal was pending, and the vessel owner was held liable at trial. After trial, the appeal was finally heard by the 11th Circuit, and the 11th Circuit looked at this, and they said, we can't allow this to happen. We have a dock construction contract, which is, okay, we're gonna call that 50-50 on maritime. He's on a crew launch. All these construction contracts required the significant use of barges to put materials and other equipment in place so that this dock could be constructed. Yet we're going to say this is not maritime in nature in any stretch of the imagination. So they looked and they decided there were two factors that need to apply in order for a maritime contract related to the indemnity, even in the bigger picture, a maritime contract, to determine whether maritime law applied. It was, were the services there to facilitate activity on the water? They decided it was. They're on a crew launch boat. They're using barges in this construction project. And secondly, was there a vessel playing a substantial role? And here they said the contract specifically calls for barges and launch boats. There are vessels involved in such a significant way that this has to be a maritime contract. The judgment of liability against the vessel owner was reversed, remanded, they were dismissed, and now this case is going to go back down for a Jones Act related issue against the employer. So those are the four cases that have come out in the last 3 weeks that I thought had some very significant issues involved, and the understanding of maritime jurisdiction in each of these cases was very significant as far as the defenses available and the potential exposure for each of the parties involved.